I'd like to introduce our speaker, Jacob Canter from Crowell and Moring. So we're here to talk about AI and the law. This is a topic that many of us here have been discussing at various points in time. I think there's a lot to learn about what's going on with the law in general around AI. We hear a lot of things in the news, but it's rare to actually hear from somebody who actually deals with it every day. And so hopefully today we'll learn a little bit. There is a presentation, but ideally there will be a back and forth with the audience here. Same thing for those who are online. If you do have questions, please ask, and we'll try to learn about what's going on in the legal realm regarding AI.
We are the SF Bay Area ACM, a chapter of the global ACM. Our chapter was founded in 1957. We promote knowledge of modern computing, and we try to create community and support interpersonal networking and hiring. Our membership is only $20 a year, and it does help us to put on more and more of these meetings. We have upcoming talks that you can see on our meetup page. Just look for us by SFA ACM there. And we have over 200 past talks on YouTube. Okay, so we were talking about calling for volunteers. As you see, we need help. And it does take a good bit of volunteer effort, but as they say, many hands make light work. So we have several people here tonight helping to put this together, and that is how we do most of our meetings. Everybody pitches in a little bit. But we do have membership services that we would like to have some more help with.
Then we'd like volunteer help with is just looking for options for locations as well. For evening meeting locations that we can book out year out.
Okay, we generally have an honor system jar for pizza when we have pizza. And we are a volunteer run, completely volunteer run, nonprofit. None of us are paid a bit. Okay, so Ron, can you introduce the speaker now?
We'll do it again, yes.
There you go.
Thank you, Bill.
You're welcome.
All right, as promised, AI and the law, we have Jacob Canter here from Crowell and Moring, and hopefully we're going to have some interesting dialogue along with what we've learned here from the slides.
Thank you, sir. Thanks, everybody here, for coming and hearing me talk. I'm really looking forward to speaking with you guys about topics in AI law and policy. We can go in as much depth or as little depth as you like. I'd like this to be a conversation. I can also just talk at you for 50 minutes. That's perfectly fine. But let's make this sort of a dialogue, because there's a lot of really interesting stuff going on. And how I've tried to organize this talk is what are the existing laws that we're currently using to regulate the use of artificial intelligence, and how is it working? Is it a good fit? Or is there something a little wrong? Is it a square peg in a circle hole? Then what are we trying to do to develop new laws to regulate AI policy? And how effective are we at getting those laws passed? And are the laws actually doing what we want to do? There's an interesting question of whether the laws are actually achieving the goals that we hope for them to accomplish for each of us and for society and for our businesses to run properly. And then, of course, what does the future bring? Everybody here knows that artificial intelligence is sort of a marketing tool. It's a term of art that is flashy, and it's actually the technology that undergirds the work that I see as a user, as AI, has been around for a long time. But we're in a sort of big moment for AI technology, and there's a lot of thought about how it'll change and how the law will react to it. So what are we expecting moving forward? So we're going to start with existing laws, because that's where the most action is occurring. And we're going to start with intellectual property. So I imagine that many people here have heard of copyright and heard of patent. If you haven't, maybe raise your hand, but excellent. So it seems like we know what we're talking about. The first question is, how exactly does the copyright law regulate the use of artificial intelligence? Why should I worry about copyright law? Well, copyright law is the method we use to protect software code. It's the method we use to protect non-ephemeral tangible expression, and code is non-ephemeral tangible expression. So if you develop and write code, then you can get a copyright over it. In fact, the moment you write it, you technically do have a copyright over it. You can get it registered, and then you can try to get it protected, and you could sue someone for infringement if they use it without permission. And that's where we're seeing a lot of action, where people are developing code, or they're using data that they've collected and compiled, and someone else uses it, and they're suing them for infringement. This can come up in many contexts. There's something called direct copyright infringement, where someone takes your code, takes your data, and then uses it in the same way that you were going to use it. That might be direct copyright infringement. Indirect copyright infringement exists also. That's when you're a secondary user. Maybe you contribute to someone else's use of your code in an improper way, or vicariously you financially benefit from the use. An indirect infringer is just as liable for copyright infringement as a direct infringer. Just a couple more steps to accomplish that. Yes, sir.
It's that prompts can be used in software, like actually, in the code itself. Are prompts considered patentable?
So
Can you repeat the question, please?
no problem, Bill. Happy to. So the question was whether prompts can be considered patentable. So a patent is completely different than a copyright. So it's a different type of intellectual property protection. It's a different type of monopoly you get over the right. A patent is a protection on an idea, and a patent would not protect a prompt, like a question that you put into a natural language system, wouldn't protect it. You'd need a patent to be agreed to by the patent office. Simply a prompt would not get recognized. Now, there's a separate question. Would a prompt be copyrighted? Harder question. Maybe so. There is an interesting question of whether a brief prompt could be recognized as a copyright, whether it would be registered. There's open questions about whether it would be registered about the originality of the prompt, about the creativity of the prompt, and about whether it's a short phrase and thus non-copyrightable under the regulations. But let's assume, for the sake of responding to your question, that the prompt is copyrightable. We're getting into really interesting issues here, because let's say the prompt is copyrightable. You use it as ingested into a model or into a tool, and then the tool is generating outputs derivative of that prompt or the same as that prompt. Well, it seems like you have your copyright and someone else is using it, right? And as I just said, the copyright laws protect your use of your non-ephemeral tangible expression. So it's possible, there's an argument out there. In fact, a lot of people are making arguments out there that the outputs of those models are in fact infringing, and the developers of those models are in fact infringers. Yes, sir.
Jacob, in order to copyright protection, doesn't the product need to be produced by an individual? So AI generates the product or the code. There's no copyright, right?
So the patent office has said that, yes, thank you, Bill. So can you have monopoly IP protection if it's created by a tool, if it's created by a non-person? And that's a good question. The US Patent and Trade Office has specifically said, in terms of patents, there has to be a natural person that does that. It cannot be a AI. I'll get in a little bit later. There is an idea of, actually, it's on this slide. Can an AI assist in the creation? That's like a slightly different question. I don't know if it's assisted. Is that created by a natural person or not? I'm not sure. For copyright as well, you're right. There needs to be a natural person that creates the expression. Software that was originally developed by a person, even if there was modifications, derivatives to the software, still, at least at this time, is being understood to be copyrightable. And so if a prompt was originally developed by an individual, then it could be your copyright, and there could be a question of infringement at the output. Yes, sir.
Do you know about prompt injection, where like you can get the AI to spill the beans on what free prompts it has on its system?
The question is whether I've heard of prompt injection. I had not heard that term. Look, man, if you're using if you're trying to get someone else's copyrights, even if it's a clever way through prompt injection, you know, you might be liable for infringement. It's not about how you get it. It's about what you're doing.
That it's not like, it can come to the same output, but if you try to like do reverse prompts or other ways to derive it back to different forms, would it ever even translate back to that original? And like,
So yeah, you're touching on an interesting topic. I'm going to paraphrase your question so we can get at it. There's an idea of like, I have someone else's copyright. And yeah, I have their copyright, but you know what? I'm changing it. I'm making it something different. I'm transforming it into something original and creative and new. And it, you know, I know it started at someone else's copyright, but it looks different now. Shouldn't that be okay? Shouldn't that be allowed? In fact, my friends, the copyright law does allow that. It's called the fair use doctrine. It's actually written into the statute that if your use is transformative enough and it doesn't use too much of the other person's copyright, then they'll say, you know what? That's a transformative fair use. You're not going to be liable for that use. And that issue of fair use is coming up quite a bit in copyright litigation. I'm litigating a case with a team at Crowell right now. It's Thomson Reuters v. Ross Intelligence, and we represent the defendants, and we have a fair use argument. I won't go too much into details, but in brief, they say that we infringe their copyrights. We're saying, you know what? Even if we assume infringement, even if we give you that part of the argument, which we don't, but even if we give you that part of the argument, we say our use is fair. We transformed your copyrights. We did something entirely different in the development of our AI technology. And that's a big question. Is the development of AI technology to do something that the original developer used? AI technology, for example, to develop a song when the original creator used humans to write the song, or AI technology to write a play when the original creator wrote a play on a keyboard. Is that fair use? I don't know. I'm not a judge. I'm just a lawyer. Someone's going to answer that question. And the answer to that question is going to be a big deal because that's going to decide a lot about what developers of AI technology can do with the models. A lot of what, I mean, you guys know this better than me, you're the technologist, but my understanding is a lot of what these technology is doing, it's allowing you to sort of generate responses that look a lot like responses that were generated from humans. It can make these processes more efficient. It can help you streamline your workflow. That's fantastic. How do you get protection over it? And how do you make sure, of course, that the original innovators get protection in their rights as well? Really interesting stuff there.
A lot of discussion about, whether AI, big AI models, foundational models and so forth could be trained on copyrighted work. And there's sort of two major camps that are arguing. One is that they can't, because that would be, I guess, driving stuff off. So we're saying driving stuff off copyrighted work. And the other one is that it's the outputs that matters. If they're producing something that's in violation of copyright, now they are violating copyright, but they might need to be trained on copyrighted work so they can recognize when they are actually, techniques to avoid that might need to train them on copyrighted work.
Yeah.
So they don't do that. So therefore, you shouldn't.
Yeah. No, Lonnie, you're hitting a good point. I want to again paraphrase your comment a little bit. Like, where is the infringement at? This is a process. It's not like a painting and I just paint the painting and I try to sell it myself, right? There's a process involved. There's the training of the tool, right? And maybe you need to use data that someone else developed. Maybe we're using a book that someone copyrighted to train the tool. Then there's the inputs to the model. And then there's the outputs that the model generates. What exactly is the potentially infringing act? Where does the infringement occur? The answer is it could occur anywhere. And plaintiffs in different cases are arguing infringement at different locations. If you're really careful, you see that some plaintiffs say that the infringement occurs in one spot, and then the infringement occurs in another spot, depending on when they're making arguments that are most favorable to them, right? And no hate, right? Like they're trying to win their case, right? That's how you do it, right? But it's touching on a really, really important question. Where exactly is the infringement occurring? How are you arguing it? And you got to be careful. I mean, this is just making good arguments, man. Like, all right, so let's look at the training. What was being trained on? How did the training occur? What was the transformation when they're building their models? What exactly did they use? Were they looking at relationships between different parts of the words, syntax relationships? What were they generating out of that? All right, maybe you could say there's fair use there, but what about at the back end? What exactly is the output? What did the output say? Copyright's about a non-ephemeral, tangible expression. If anyone says that their paraphrase of your book is an infringement, hold on, maybe it is, but maybe not, because it's not the same necessarily. Yes, Bill.
There is a question from the remote audience.
I'll take a look, man.
I'll tell you what it is if you like, or yeah, if you can see the chat.
I cannot, isn't the fact that generative
Okay, let me
AI
just read it to you. This is from Daryl.
I got Bill,
L3.
don't worry about it. I got it. Isn't the
Okay.
fact that generative AI was used to qualify the work as novel and therefore protected under copyright law, much like the Campbell soup can painting? Yeah, I understand the question. The answer is no. Novelty is not a relevant factor in infringement if you're saying that it was a copy from someone else's work. Now, maybe that's an argument you're going to say that it's different. Maybe that's an argument that you're going to say that it's a transformation, but novelty is not a technical term in copyright. Novelty is a technical term in establishing a patent, right? But if you, and maybe you're going to say that you weren't infringing someone else's patent because your idea was novel, but just the fact that it was generated out of Gen AI doesn't presumptively give you a novelty argument at all. Look, I mean, like if I'm a defendant representing a party that's alleged to be infringed, I'm going to say that my idea was super novel.
I mean, how
Correct.
might you,
Yeah.
how might you claim that Warhol's painting is reducing the commercial demand for soup?
Well, yeah. So you're asking an interesting question about fair use, right? And there's one of the factors in the fair use analysis is sort of the impact on the market. And
Yeah, actually, I was going to actually, if you'd help me untangle that, it's not so much fair use,
Yeah.
which is an American concept.
Yeah.
As was also something that's a little different from trademark law, which is domain of use.
sure.
That reusing that label on another label of your soup is clearly wrong, both from trademark and copyright perspective.
Yeah.
But it's definitely cutting into the market for the work.
Yeah. Right.
But in a way that maybe using it in art, reason
Yeah.
the song might not.
Yeah.
Is that a relevant concept or an irrelevant one?
Domain of use is absolutely a relevant concept. And this is, and thank you for bringing this up. It was asked about, the question here for everyone on YouTube or on Zoom was about the domain of use or impact on the market analyses and whether that applies to generative AI and the potential copyright infringement claims. Absolutely it's relevant. It's relevant, one, because it's still the law. This is the same law. Just because it's a new set of facts changes nothing, right? And maybe your point is that it feels a little weird that we're applying this old law, a law that literally is hundreds of years old, to this new technology. Still the same law, still got to apply it. Now, how does it turn? I mean, these are hard questions. Like, how does it turn? Anthropic generated a song based off of Concord is a record label. They own a bunch of songs, right? Anthropic generated songs that really sound like songs that Concord owns. Really sounds like songs that Concord owns. I think it even takes some of the licks that Concord owns, right? All right. Now, Concord's going to say, what the heck, guys? I spent a lot of money on these songs. I'm trying to like be a business to protect the creators. I'm trying to make my own money. You guys just generated something and now you're going to make songs that sound just like it and you're going to make money off of that? That's not cool. This is the same market. You're going to buy Anthropic's song rather than my song, right? I kind of get it. Anthropic's going to say, whoa. This is a completely transformed idea. This is generating music out of a tool that is transformational. This is a transformation of the properties of your song into something that's an output that is, yes, the output does look similar, but the process that went to accomplish that is foreign to the process that went into creating the song originally. Shouldn't that be meaningful? And I guess my answer is, I don't know. I'm not a judge. Someone else will decide that, right? It's an important question, though, and there are smart people on every side thinking about these issues, right? We can keep going. There's other interesting stuff, or we can stay on copyright. Yes, Greg.
I have some familiarity with patents.
Yeah.
But not copyright.
Sure, sure.
To make an analogy with patents, you have to have, something that wouldn't be, easily invented by a normal practitioner.
Yeah,
As-
that's right.
As far as a novelty.
Yeah, that's right.
And so with, like a copyright on code, then if it's something that a typical person would do, it's a normal best practice. Is that something like in the prompt engineering?
So yeah,
You read papers about it, they say, take a deep breath.
yeah. So you're getting into a really, so we're getting kind of deep in the copyright law. So there are concepts of copyrightability. So there are some things that are copyrightable, and there's some things that are not copyrightable. One of these principles in copyrightability is the merger doctrine. The merger doctrine provides that if non-ephemeral tangible expression merges with the idea underneath it, then we're going to say that it's not copyrightable. What does it actually mean for a expression to merge with the idea underneath it? It's hard to get there, right? It's not often does expression merge with the idea, but a paradigm case in the literature is when you create a tiny beetle out of metal. And they said that that tiny beetle was an expression that we created. And they said that that tiny beetle was their copyright. The judge said, there is no way to create a tiny beetle out of metal that's supposed to look like a beetle, except in the way you did it. So no, you're not getting a copyright over that expression. Now, how does that apply to the software context? There are some examples in the literature where courts have really just said what Greg said. Look, there is common methods for developing these code. This is how everybody does it. We're just going to say that this is not copyrightable. This is just the same as the idea of expressing this concept, right?
They asked me to turn on the video on the computer.
Oh, sure, man. Whatever.
Wait, is the theory of merger why facts aren't copyrightable?
The fact, the principle that facts aren't copyrightable is actually in the statute.
Oh,
The merger doctrine is common law made, is judge made, but it's a similar idea. That's right. Yeah. Yes, Ron.
So what about data and the technical laws around the data?
Yeah.
Seem a little more tangential to.
Yeah.
that.
Yeah. Data can be copyrighted if it's in a compilation. A collection of data, when compiled, can be copyrightable. So, for example, the facts about the Pacific Ocean. Imagine a folder with 100 facts about the Pacific Ocean. Those facts, as Rohit just said, not copyrightable. That's just in the statute. Facts are not copyrightable. But the collection, your choice in the selection and arrangement of those facts, that can be copyrightable, right? Because there's something tangible and non-ephemeral about your decision about how you selected and arranged those facts. For example, maybe you only selected facts about the southern part of the Pacific Ocean, and maybe you arranged them in alphabetical order. Maybe you only selected facts about a certain depth in the Pacific Ocean, and you arranged them by level of depth in the ocean. That selection and arrangement can be copyrightable, and you can protect that in an infringement claim. If if you think that one of the LLM developers took your compilation and took that selection arrangement and copied that selection arrangement, then that can be a copyright infringement claim and that you can possess it. Data, when the data is copyrightable in itself, that can be copyrighted, even if it's part of a compilation.
is the compilation doctrine how like Westlaw page numbering and chapter headings are protected, but it's public domain content? Or is that?
Maybe explain the example.
Yeah, there's
And repeat the question.
yeah, so Rohit's question was about a specific method of organizing that's used in the law. And it's a method of organizing that was developed by the West Publishing Company. It's called the key number system. And the key number system is a method for organizing topics and cases within the law. Let's say you have a case on copyright or a case on contracts or a case on property. There's a system for organizing it. They placed cases on those topics within that system, and they're going to say that's an organizing method. So here's my honest answer, Rohit. I'm litigating that issue right now. So I actually can't probably talk about it publicly, but let me say a couple comments on that. There are principles in copyright law about expired copyrights. Things that were created before more than 95 years ago under the Copyright Act no longer get protection. Why? Because we don't give you a life, a protection forever. There's a principle that the innovation requires that it gets in the public domain at some point, right? So some things that were created a long time ago don't get protection anymore. Also, principles that are part of the components of a key number system might not get protection, right? If it's been around for so long, if it's part of the sort of method of thinking about legal principles, then it might be merged with the ideas underneath it. What is so novel about the idea of contract law being distinguished from property law? And who came up with that? Did West Publishing come up with that? Someone else is going to have to decide that than me, but I have my own opinion on that one, right? It's an interesting question. There is a lot of doctrine around compilation copyrights. For purposes of AI, I think one thing you would think about is what exactly is the tool ingesting? And what exactly are you doing when you're developing, when you're training on a compilation? Are you training on the words? Are you training on the organization of those words in a compilation? Are you training on the relationship between different words that are represented numerically? I mean, I don't know. All right, one more, and then we're going on another topic. Yeah.
Just a technical observation
Yeah,
that LLMs are exquisitely good at extracting structure you didn't think was there.
Yeah.
So if you did give it an ingested PDF and it happened to have been arranged in some order of headings and Dewey Decimal coded, say, in that order, it might be able to relearn the Dewey Decimal server in numerical order without you even asking it to do so. That's
or it could learn some other entirely different method you didn't even realize.
yeah, you want to do.
Yeah. Yes. Yeah. So it's a great question. And so the question is, can you patent an AI assisted invention? So here's what we know. The Federal Circuit, which is a circuit that sort of develops a lot of the patent law, has said pretty definitively that only a natural person can get a patent. If it's 100% AI created, then you can't get, then that can't be patentable. And that's the Thaler v. Vidal case. The U.S. Patent and Trade Office has since then, actually, I think yesterday or something, came out with guidance. And the guidance is on, can you patent an AI-assisted invention? And as so much of this guidance from the federal government and its agencies is, the answer is maybe. There needs to be a natural person involved. The natural person needs to be, this is kind of in brief, the majority creator, right? The majority inventor. But perhaps in some circumstances, the contribution of AI assistance could be allowed in the creation of a patentable invention, right? I actually am not aware of any inventions that have been patented yet that at least in the terms of the patent say it's AI assisted. But look, the USPTO said there's guidance, so I think in probably a year or two we're going to find out, right? It's where the rubber hits the road when we actually see if it comes out, as a patent or not. Guidance is nice, but we got to see action.
Drug companies are using alcohol now for.
Oh yeah, I mean, and there's a lot of money in those potential patents, right? Like, there's a lot of interest in getting that to work, right? Yeah. We've successfully accomplished one slide in about half the time, so congratulations, everybody. We're doing great. Yeah. I'm going to go to. Okay, privacy and data security. We're still on existing laws. So I think we all here recognize, I mean, push back if you want, but I think we all here recognize that it's good to protect someone's personal information. Like, and maybe there's value in the sharing of it. I'm not fighting that. But if someone has personal information, or you have health data, or you have financial data, or you have just proprietary data that's business sensitive, you kind of want to protect that, right? Right. There are, and this is always a harder discussion with lawyers, but I think with you guys, this is gonna be pretty intuitive. When you're exposing that data to a third-party tool, other people are getting access to it, right? And like, as a technical matter, are you okay with their access to it? And then as a contractual matter, have you allowed them access to it? If the data is from a third party or a consumer, have you told the consumer that that data is going to be exposed to the third party? Are you confident that the third party has security measures in place to protect it? Or are you going to get like a SolarWinds incident where you're exposing data to a vendor, that vendor is not protecting their software, it gets exposed, it gets hacked, and then now all of your data that you've exposed to the vendor is exposed to that threat actor as well. I'm bringing it up right now because it's not just sort of like yeah, I agree we should protect personal information and my business information thing, which good, but there's actually laws that, can get you in trouble if you don't do that, right? I'm not going to walk through every law. That's boring. I'm happy to talk about them if you want. But the upshot is there are laws that are going to get your company in trouble if you don't protect data and if you don't think about the protection of data. Some of them are, regulations where the government will come after you. Some of them are have consumer rights of action where a class can come after you, a class of consumers can come after you. There's a lot of ways that you can protect it. I mean, we talk about data minimization principles, just the idea that, if you get data, you have a reason for getting it, only use it for that reason. Don't use it for other reasons. Once you're done with the reason, get rid of it. It's kind of one idea. Sign data processing agreements. That's actually a principle that's required under certain laws nowadays, where you're like letting people know, hey, you're going to process data. Here's what you're allowed to do with it. Here's what you're not allowed to do with it. Important stuff. Becoming more and more important every day as all of our personal information is going online and all of our transactions and business and personal activities online as well. Yes, Ron.
Any comments on, I can't think of the name, there was a recent thing passed here in California about adding a kill switch.
Was that like a proposed law?
Yeah, I think what I read was that it had passed.
Okay. So the question that Ron asked was there was a law that might have passed that I'm not aware of about a kill switch to basically, I assume what they're talking about is getting rid of someone's data immediately.
I think it's turn off the evil AI.
Yeah, I think
Well,
it's AGI kill switch.
AI safety bill.
Yes. Okay. So I do not believe that's passed. I believe that's been proposed. Yes. So yeah, the AI safety bill. Well, I mean, I don't know, man. It's probably not going to pass. But
Well, what I'm thinking is that for AGI, I get it, right?
Yeah.
Stop the
Yeah.
Terminator.
Yeah.
But I assume between now and then, there's lots of reasons people will want to do a kill switch.
yeah.
right?
Yeah.
From
Well, and well,
Especially when the cat is out of.
so I'm not going to assume that I know more about the technology than you guys. That would be a bad idea. Here's what I will say. There, and we'll get to this slide later, but there has been a lot of proposed legislation. There's been little legislation that's passed. There are interesting theories for why that is, and there's theories of democracy and theories of sort of like common interest groups and all that jazz. The point is, what's going to get passed is, I think, going to be, narrow and sort of precise. That strikes me as a broader law. I mean, it seems unlikely that something like that's going to pass. Again, I don't really know. Like, that's not my bailiwick.
Yeah, I'm thinking even with data, not the robots, just
Yeah.
we see you taking all the internet's data. We know if you hit, sort of projected point, it means bad things, right?
Yeah.
Can we, stop?
Yeah. Well, and as a legal matter, it's important as a regulatory matter and to protect your liability against potential suit to be aware of the data that you're collecting and how you're using it, because there could be problems if you're unaware or using it in without aware, you're using it in ways that you're not supposed to, and then that could lead to legal risk, right? Antitrust. This is a sort of the last piece of existing laws that are sort of coming up in the AI space that I thought it'd be interesting to talk about. So the antitrust laws have been around for a long time. They're used to sort of promote competition and to ensure that the competitive process remains sort of undisturbed. not anti-competitive, right? And there's a lot of interest from the antitrust regulators, that's primarily the Federal Trade Commission and the Department of Justice, in making sure that the market that's developing around the use of generative artificial intelligence remains competitive. This has included sort of requests for information from the FTC to learn more about the market for sort of the cloud market where, for the infrastructure that's running a lot of the LLMs, and also to learn about the major players that are building the technology from the hardware up to allow this technology to sort of exist. And you might have seen in the New York Times that there was a disclosure that the FTC and the DOJ have made a deal about who they're going to focus on for their own investigations. Within antitrust circles, that's a big deal. That means that, the FTC and the DOJ are thinking about investigating these big companies and thinking about whether, ultimately a lawsuit would arise, and a lawsuit that impacts, for example, how one of these big companies can operate, whether allowed to, the injury, the damages or the effects of a lawsuit can be anything from monetary damages to divestiture. These are pretty large, significant impacts. And so when thinking about the market for the licensing of end user technology, AI technology, to licensing GPUs, to the use of cloud technology, where a lot of the developers that are building on top of LLMs are operating, what that market looks like, there's a lot of concern and interest at the regulatory level on how that's operating. And, that's going to impact our ability to sort of how the market looks ultimately. It's slow moving, as the law often is, but we're going to see interesting stuff happen there. We keep moving along. So we were just talking about laws that exist and what we're doing. The next piece is laws that don't exist yet, but that we're trying to create. And that's actually pretty active, but it's active in a way that I would say has not, at least in the United States, led to much passage. I'm going to start with the federal government, right? And the way I've talked about this in other presentations before is that the federal government clearly has an interest in regulating artificial intelligence, or to be a little more precise, in regulating the companies that are in the AI market to ensure sort of our interests are protected, that the use is safe, that there's not discriminatory use, that our data is safe, that there's options against sort of the AI monster, and that we're protecting against that or whatever, right? But there's been very little legislation that's actually passed. In fact, Congress has not passed any laws that are actually tailored towards the regulation of artificial intelligence. There's been a number of hearings. The Senate has had quite a few hearings to try to understand the market, understand what's going on, and to hear from industry leaders, academics, think tanks, what they think are the best ways to regulate this market. It's led, for example, to President Biden having a blueprint for an AI Bill of Rights. It's led to Senator Schumer just a month ago coming up with a roadmap for AI policy. But it hasn't led to the passage of any laws. On the state level, we're seeing a little more activity. Colorado just recently passed the law against the discriminatory use of AI tools. This is actually a pretty big deal. We didn't think Colorado's governor was going to sign the bill. He did. Okay. We got a new law coming into effect in a couple of years, right? In New York City, there's a law specifically regulating the use of automated employment decision tools. It's kind of the same as AI, kind of different. Those differences are important if you're actually in the market for AI tools related to the hiring or promotion of people in New York City. You should talk to someone that's looked at this law. It's a big deal, and it requires a lot. You can get, you could be sued by the New York Enforcement Agency, or can there be a class action claim, right? So those are things to think about at the state and local level. And also within the state, there's been also a ton of activity about proposing laws. Yes, sir.
Like key keywords like ADD that we should know, like specifically that refer to AI from things like random?
It's a really good question. Yeah. So the question is, I'm going to paraphrase a little bit. I think this is getting at it. Technologists here understand that artificial intelligence is kind of a loose word, and the technology underlying it has been around for a long time. What are the, in the laws that are passed or proposed, are there any sort of keywords that we should be keeping in mind to say, oh, this is going to be an AI law. This is something we should look at so we could be aware that this is going to maybe impact my business, or it'll impact a tool that I've been developing or licensing. More recently, legislators have gotten better about saying it's an artificial intelligence law. So actually, it's getting a little easier these days. The reason is because it's kind of flashy to put in your proposed legislation that it's AI related. And so legislators are more interested in doing that. I think that's probably what's going on. A couple of years ago, where artificial intelligence wasn't such a flashy word, this was when the AEDT law was first proposed. It was less common to do that. And frankly, I think that there's been a real paradigm shift in policy circles where a couple of years ago, you kind of looked silly and not legitimate if your law was regulating AI. And nowadays, if you're not drafting a law that regulates AI, you don't look serious. And it's sort of really interesting to see how that could occur so quickly. But you're going to see a lot of laws that are regulating AI. What you should be careful of is how the law actually defines AI, because the definition can be, they're all going to be roughly the same. Don't get me wrong, but the devil's in the details, and those details can really matter when it comes to whether your deployment of that tool is in fact going to lead to potential liability. Yes, Ron.
From the ones that have happened and maybe other ones you might hear of, do you think there's any like market making laws, like we're just not going to Nebraska because the AI law is crazy, right?
Yeah.
Everything will be done outside of.
Yes. So the question is, are there any laws that are coming up that would be like so significant that you might see it changing market behavior, and even so changing market behavior that would sort of be a disincentive for companies or users to just be operating in that jurisdiction? Sitting here right now, I can't think of a specific law that is close enough to be actually becoming law that fits that sort of characteristic. There are a ton of proposals that when you look at the proposal, you're like, this would be pretty significant in its impact on the market. And it's kind of crazy that someone was actually proposing this. But there, if you're a legislator, there's no, it's not, laws get proposed all the time. Like I would not say that alone is a barometer for whether you should be concerned. And to that point, my firm, we're tracking, the development of the AI market. And for a while, I was tracking proposals of AI laws proposed on the West Coast and West Coast states. And after a while, I was like, this is not useful for businesses, because these proposals, there's so many of these proposals, none of them are going anywhere. And like, who's going to get anything about it? Like, I want to track when it's a useful proposal, when it has legs, or it might be a plausible one to become law. But there's just such a significant volume that like you're not seeing stuff that might really have an impact. But to complete my response, Ron, where are we seeing laws that would, I think, affect market behavior? I think the election advertisements. Over 40 states have proposed laws that would say require something like a transparency disclosure, or even an outright prohibition on the use of AI technology to develop advertisements for election purposes. I do think that some of these laws are going to pass. That's my one prediction. I do think one of these laws is going to pass because I think that they're relevant for the November election. And I think there's going to be we're getting really close to the election, so I don't know if it's going to be applicable for the election. But I think that they're going to pass, and there's going to be real questions about the constitutionality of those laws, and also about, practically how are they going to be enforced, and how they're going to impact the behavior of politicians. Yeah.
What about the European laws, and what impact they may have in US?
You're asking about the European laws? I'm going to get to that next. So we're almost there. Yeah. Yes.
We don't want people to do bad things.
Yeah.
What tool they do to do the bad thing?
Yeah. No, so it's such a good question. And so the question is, why would you draft a law that's targeted towards artificial intelligence when, like, artificial intelligence, it's just a tool. There's lots of tools out there that could be used for good or not good. Why would you target the law towards AI? So it's a really, really good question. I think there's a number of possible answers. One, you get more clicks if you draft an AI law nowadays. And so you want to draft your law that's AI targeted. Maybe that's one. Maybe, I don't know. Like, that's not crazy, right? That's how they stay elected, right? They got to be numb. Another one, is that when the law is targeted towards AI, there's a clear signal about what you're not supposed to do. And yeah, maybe it's under-inclusive in a broader sense, that it's not touching everything, but it's clearly addressing some concern. There's a real concern for a long time in California about members of the movie and television industry using the likeness of actors to sort of exploit those likenesses for their own sort of commercial uses. And there's a real concern in the legislature, members of the legislators, that's going to like destroy the movie industry and the television industry. So there was a proposal in California to prohibit that, to say that any contract term that would allow for the name use or the likeness or something like that, a likeness of an actor or someone, is immediately presumptively unenforceable. And so, yeah, there's a lot of provisions in contracts that are bad and should be unenforceable, or that could be bad or unenforceable. But we really want to make sure that one's known, right?
Any character is not intended to be used for that.
Yeah, that's another way of regulating it. That's right. Yeah. And so, sir, you got
About what happened on Volkswagen, diesel, yellow beetle that they had to recall because the engineers programmed it to pass a test.
Oh, yes, yeah.
Dieselgate.
Yeah, I do remember Dieselgate.
Yeah. What's to stop AI from doing that?
I don't know. Okay, well, what's the question?
I think the only solution that you can ever really have is to do two things. One is to either give it training documents that are not abstract, but very clear examples. Like, don't say the word malicious, but you literally have to say, like, this cannot end in the result of somebody getting hit.
I think I understand the question. Let me see if I understand the question. Sometimes, I mean, these are powerful tools. You guys know much better how these tools operate than I do. And it's possible that these tools can do bad things, even if we legally prohibit it, right? The law is just, a piece of paper, right? I mean, like we have the government to enforce it, but like, it's just a piece of paper. The technology doesn't need to listen to it. So how do we actually enforce those laws? Well, you're correct. We can sort of draft into the training and the development of the tools these sort of like guardrails. The term guardrails is one that we've used a lot in sort of the development. And we can make the enforcement mechanisms sturdier and stronger. And this is a common concern that we've had forever with all technology. Technology always is moving faster than the laws. Yes, Bill. I'm gonna look at them right now. The question is, once your data is used in the training of an AI system, it is impractical to be removed. How will it be enforced? It's a really good question. The short answer is that's not the legislator's problem. And I want to be very, very clear here. Like, that is not the legislator's problem. That's the technologist's problem. And if the technologist wants to be in compliance with the law, they might have to figure it out. In a little different of a context, the Federal Trade Commission got mad at a company for improperly collecting consumer biometric data and using that biometric data to develop their technology. And they were very concerned. Like, look, this is sensitive information about a ton of people. You didn't tell them you're collecting it. This is serious. Like, you can't just collect people's biometrics without telling them, then using it to make commercial gain. You know what? Any technology that you developed with this, You can't use it. It's illegal for you to use it. And they were like, what do you mean? Like, we spent a lot of time and money building this. This is a really big deal, FTC. We can't do this. FTC was like, I don't care. You shouldn't have done that. Rewind everything. And they had to rewind everything. Excellent question. I mean, and this is, and like, look, man, like, look, you could say the technology is stronger than the law. Like, and I'm not going to fight that. You guys know the technology better than me. The law's got teeth too, right? So you're going to listen to it or not, right? Chat. Okay. The question is, how do the state of US laws compare to laws in other markets? So this is a very good question. I'm going to jump to the EU because there's been a few questions about the EU and where we have seen legislation, where we have seen something passed. And this is very different in the United States. Like, there's a couple of examples in the US where it's specific laws tailored to specific activities, specific types of conduct. In the EU, something very different's happened. They've passed, it's not going to go into effect for a little while, but they've basically passed something called the Artificial Intelligence Act. And this is my only image that I'm putting up here, but in my mind, this image describes the entire AI Act. I think it's a great image. My colleagues in Brussels would be very mad at me if I said that, because the AI Act is in fact substantially more complicated than this. But to me, this is the entire thing. First, Brussels effect. It means that any AI tool that is in the EU commerce is going to be regulated by the AI Act, even if it's built in Berkeley, even if it's built in San Francisco. If it's in EU commerce, it's going to be regulated by the AI Act. That's the first thing. Second, what is an AI system? There's a definition. It's pretty darn broad. It doesn't cover everything, but it's pretty darn broad. And how do they regulate it? It's a risk-based classification approach. It's very formalized. And they spent a lot of time figuring out and thinking about how to organize these risk-based approach. There's unacceptable risks, and certain tools are unacceptably risky. Not allowed to use them. High risk, that's not quite unacceptable, but it's not other. It's difficult to figure out what that means, but they've tried very hard to delineate it clearly. When it's high risk, you have certain use obligations and disclosure obligations. Everything else, it's just a disclosure obligation. Simple enough, right? Obviously, it's going to be much more complicated when you're actually a deployer or a developer trying to use it. And there's all these carve-outs. For example, there's a carve-out if it's just for research purposes and not for commercial purposes. But this is a really big deal. And this is nothing like what we've done in the US. Again, in the US, Congress has not acted. The states have done some stuff, but it's been really piecemeal. It's use specific. The EU has said, we're going to regulate everything with this one law. It's not going into effect for a couple years, but it is a big deal. If you're doing commercial activity and you're developing or deploying, you got to think about how the AI Act is going to impact you. I want to make sure I get to the last question on here from Carl. Who is behind writing the new laws that are being put forward? If the question is legislators, I'll say on the federal level, Senator Schumer out of New York has been very interested in drafting AI-related legislation. But frankly, on the federal level and the state level, everyone wants to get in the AI game. There's a ton of money involved. There's a ton of interest involved. It's impacting a ton of people. This is the type of thing that legislators are interested in. The president of the United States is interested in it. Governors of every state are interested in it. This is a big deal. If the question's like, is there interests behind the legislators that are also interested in the development of laws? I guess I don't know. I presume so, right? This is a lot of money involved. It affects a lot of people. I am sure that there are civil society organizations that have a huge interest in it. I'm sure that there are technology trade associations that have a huge interest in it. Why wouldn't they? It's a big deal. These laws are going to impact a lot of people and a lot of commerce. Of course they would. All right. How are we doing on time, Ron? We're okay?
You go.
No, I just want to.
If you want to go 20 minutes, 30 minutes.
All right, I'll keep moving. Really quickly. Oh yeah, what's up, man?
Your previous slide on EU.
Yeah.
Do they give any indication of criteria that are acceptable?
They do. I was being a little fast. They said they do. So so the question is, do they give some sort of definitions for what is unacceptable risk, high risk, or other? So that's correct. So an example of unacceptable risk would be I believe, and I believe an example of unacceptable risk is using AI technology in the development or the management of a nuclear power plant. Like that would be one of them. Like it just nuclear power is a really, really intense thing, and you want to be we really want to be careful when we're managing nuclear power plants. I believe, and I think there was some, yeah, I think bioweapons. Thank you. Bioweapons is another one. And there's some rule about the use of AI for in certain police force activities that I think is covered by it as well. So I mean, it's I don't know all of the specifics, enumerated, prohibited versus high risk uses. It's written somewhere, and you know maybe I could like find the list and send it around to the ACM board at some point. But it's a good question.
Nice down to her question. Why need a specific law for AI? Whereas all the backwards driving them, so it's some of the things also because AI proliferates, whereas other things limits it.
Yeah, yeah.
That's probably the reason why you need that specialty for AI.
I think it's totally right. I think it's a good point. I think it's a good point. And the point that was just made is that AI is proliferating in ways that like are unexpected and hard to anticipate. And so maybe there's a specific need to regulate the tools that are causing that proliferation. Really quickly, if I were a private company in the United States, I'd be like, what the heck am I supposed to do here, guys? This is kind of lame, right? You're telling me that there's all these laws are going to be passed. None of them are actually passed. There's a law in a jurisdiction that I barely do work in or don't do work in where something is passed. So what am I supposed to follow exactly? How am I supposed to make sure that I'm protected now and in the future? You're telling me there are going to be these laws are going to be passed, but not yet. Two things I would say, internal governance policies, like have an AI ethics policy. You already have an HR policy. You already have like an acceptable technology use policy, probably. Have an AI use policy. Think about how people in your company are going to use it. Some things to think about, only license tools when there's a legitimate business purpose for licensing it. Don't just license it because of whatever. Only allow persons to use the tool when there's a legitimate business reason for them to use the tool. Role-based access to the tools can be a nice way of handling this. Having a written consent to use the tool can be a nice way to handle this. Reminding people that they can't put proprietary information in the tool can be a nice way to handle this. Have your contracts organized. Have your chief information security officer look over the licenses to make sure there's not security concerns. Just some things to think about. If you're developing these technology, make sure your IP is protected. Copyright registrations, patent prosecution, these are all options that you can take. Something to think about, right? Right now is the time to think about protecting your tools and your technology and your company, right? Because like the laws, I think, are coming. All right, and we're getting towards the end. So we've talked about the laws that exist and how that's impacting the AI market. We've talked about the laws that might be coming soon and how that might impact the market. Where are we going to go in the future? What is it going to look like? The technology is here to stay. What's it going to look like? I do not actually know. I have no idea at all. That is my honest answer. I have no idea. But I will give you 3 predictions on what's it going to look like. We're going to get clearer guidance on what uses are legal and what uses are not in terms of IP protection. There's just enough litigation out there, and the litigation is significant enough and it's creating enough novel, complex questions that it's very likely to me that an appellate court is going to make a decision that impacts and provides guidance on how to behave. Ultimately, guidance is a good thing. In the law, at least, the presumption we take is like, look, businesses are going to be behaving in all sorts of ways. Then there's businesses all around. Clearer guidance. And maybe some businesses prefer X and some businesses prefer not X. Like that's just part of life. Clearer guidance at least gives us guardrails and roadblocks for how we're supposed to behave in a legal way. And so that's a good thing. It takes a long time. I don't think that we're going to get guidance soon. But like by 2028, 2029, like it doesn't seem crazy to me that by then we're going to get, maybe even earlier, but like certainly by then, like we're going to have some clear sense of like what types of uses of AI technology or data or training data to develop AI technology are legal and not. I think that in the United States, we're going to get more targeted legislation. The United States has not been good about broad legislation in the technology space. I don't think we're going to get something like the AI Act. I think that is unlikely. I specifically do not get paid to do this, so I might be wrong. And like I said, I don't know, but I do not think that's going to happen. I think we're going to get targeted legislation. Yeah. Yes, sir. Well, that's okay. Just, it's a question.
Other chip, like dedicated for the law on the mother tool. I think that's the only way you can do it. You can have it as like a middleware chip, that everything goes in between this chip and then some way it routes around.
Well, so the question.
That's plenty of time for a bunch of people to get new computers. So it doesn't become a decentralized problem to take down. Now you're left with the one bad actor that has some mega computer somewhere. And where do you find that? That person could be hidden behind proxies and all kinds of things like that. And I don't think you could really regulate it through software because I'm not a cybersecurity person, but I have written self-modifying code. So you can't really detect code that modifies itself when the function signature is changing.
Yeah, so it's a really thoughtful point. So I think the idea is like, look, again, like the technology is strong. It's self-modifying. It might change. How in the world can laws actually regulate it? Maybe you have to use hardware to regulate it, and I'll get you in 1 second. Maybe you have to use hardware to regulate it. I'll say it again. I'm not the technologist here. You guys know it all better than me. Maybe hardware can regulate it. Maybe that would be a really nice, clean solution. Also, maybe the police power will regulate it, and also maybe the power to enforce civil penalties will regulate it, and maybe also the power to shut down companies that are violating the laws will regulate it, or maybe the power to prohibit the sale of goods on the marketplace will regulate it, or maybe the power to put people in jail will regulate it. I don't know. I mean, like these are fair questions, and I don't know the answer, but
The other AI will regulate it.
maybe the other AI will regulate it. Yeah. Yes, sir.
Like demonstration on like a League of Legends AI bot, and then like a couple of years later, I was working at a company that was using GPT 3.0 for language processing, and then suddenly ChatGPT came out. It was like, wow, that's the same thing, like the same model kind of thing. And then the law in the future is one thing, but looking back, these were like nonprofit companies that like everything was done under the guise of nonprofit. Everyone was like, oh, okay, it's nonprofit. Suddenly they're like for profit and everything is like a for profit thing. And like in the future, I think like we should let AI grow, but will there ever be some kind of framework to do like retroactive and say like if there were some clear laws that were broken here and there needs to be some kind of compensation for the period of time between like the past 10 years or something?
My honest, I mean, so the question is, I think I understand the question. I think the question is that in the past, the development of AI was done by companies that were sort of registered as nonprofits. When you're registered as a nonprofit, you get tax benefits because you're not sort of making a profit, and you have specific goals in mind in your charter that allow you to have those tax benefits and to recognize the tax benefits. And then it kind of sucks if they then may turn into a for-profit company and then make a ton of profit and are just killing it in the market. I mean, I honestly am not a tax lawyer, so I don't know if there's I just don't know if there was a legal violation there. I have no idea, to be honest with you. I know that that's being litigated. Maybe someone else knows. Do you know tax law? I do not know tax law. Okay, yeah. So, look, if there's an injury under the regs that's cognizable, someone's going to look into it. So someone's going to answer this question, not me. Yeah.
It's very informative.
Yeah.
Question for you to speculate on.
Yeah. Okay. Mhm.
Do you think software uses neural network where you don't necessarily fully understand the problem?
Yeah. Yeah, so it's a really, really good question. It's a really hard question. So in order to get a patent, you need to go through a process. So I'm just paraphrasing in a way that's not as accurate or precise as your response, but I'm paraphrasing for the people on the Zoom. In order to get a patent, you need to go through a process where you describe your patent, and it needs to be sort of specific and accurate. But when you're patenting something that it's a neural network, and you don't actually really know what the process is, it's a black box. How are you going to accomplish that? Here's my speculation. The U.S. Patent and Trade Office and its sort of prior versions has been an extraordinarily successful agency for the U.S. government. Frankly, I think it's one of the most successful by far, and I don't even think it's close. The amount of innovation in the United States has been frankly stunning. In the last 200 years, the amount that we've accomplished as a country through the innovations and through the copyright and patent clause of the U.S. Constitution has been amazing. It's probably our best contribution to the world history, frankly. I would be shocked if the patent office isn't thinking about this now. And I would be shocked if they don't figure out how to do this well. I think it's a big deal. It's a really good point. I just think they're like this. People got problems with it. I get it, but this is one of those agencies that's done a good job. Yes, sir.
So how would you get a patent for something that cannot be recreated from that description?
So the question is, how can you get a patent for something that can't be recreated from that description? Man, I don't know. I really don't know. Yeah, I get it.
Neural network that's doing
Yep.
black box.
I get it. I get it. Like I hear you. It's a good question. I honestly don't know. I just like there's a lot of agencies that have not done a great job. The patent office has done a great job. Yeah.
We don't understand what these things are doing, but in fact, we understand every detail.
Yeah,
of
maybe
what they're doing.
maybe reject the premise. Right. Yeah. Yeah.
Problem is, there's so many of them.
Yeah.
We don't, we can't handle the complexity of all the things that are happening.
Yeah.
Down at the bottom, lowest level, we know.
Lonnie, I get it. Lonnie, I get it. See, maybe you reject the premise. Yeah. Yeah. Yes, sir.
Preventing. Do you see the spirit of the laws that are kind of like making to prevent bad behaviors, or is it to potentially sanction outcomes? So if you do something bad, so is it like deterrence or is it preemption?
Yeah. It's a really good question. When I've seen laws that are sort of prohibitory, right? And not all the proposals are prohibitory, right? Some of them, for example, are like, let's do research and let's do public-private partnerships for research. But when I've seen prohibitory laws, I think there's a real fear of bad behavior. I think that's what's going on. I think it's deterrence. And I think that's what I'm seeing generally. I mean, each legislator is different and they got their own priorities, right? You know what I mean? But I think what's going on primarily is a concern about people abusing the technology and humans behind the technology using it in bad ways. That's what I think. But I mean, like, is it true that there are laws that are worried about the outcomes? Heck yeah. Heck yeah. Of just a few more, because I know we're ending soon.
We know there's any progress in the US about this debate whether opt out versus opt in terms of age.
Yeah.
It's one thing I'm concerned about is kind of quality of life.
Right.
I've been hearing stories, for example, of that cars now are taking your data and selling it to like insurance companies.
Yeah.
All these other companies are using AI to basically kind of almost perfect price gouging to science to eat like toward each individual.
Totally. So I mean, let me. The question is, you started a question about opt out versus opt in. It got to a point where it's a concern with sort of like the improper use of data. And so I'm going to go back to this data minimization idea. That's pretty well known in the privacy data security space. Like, the idea is that if you're giving someone else your data in whatever form, biometric, personal, financial, driving behavior data, whatever. You know that you're giving the data to them. They're telling you how they're using it. And once they're done using it that way, they get rid of it. In the United States, generally speaking, this is kind of painting with a broad brush, but generally speaking, they're allowed to do it that way unless you opt out. They just have to tell you. There's a transparency requirement. Europe is different. Europe has much more of an opt-in culture. In the United States, you're seeing more opt-out. How you protect that is hard, and how you are vigilant in the protection of that is difficult. But that's sort of the policy balance that we've struck, right? We've decided that we want to allow the innovation of technology, and we're going to protect the users through a transparency and opt-out method. All right, yeah. Yeah, you know what? Yeah. Yeah, you know what? Let me just say, this has been really cool. It's been really fun to talk to you guys. I'm around. You can contact me via email, or I don't know, some other way if you can, LinkedIn or whatever. I really appreciate it. Thank you guys for being here.
All right, thanks again, everybody, for coming to Jacob's talk on AI and the law. Jacob will stick around for a few more minutes to have any follow-up questions. And if there's any further questioning after today, we'll be sure to email Jacob and try to get a response. But thank you, Jacob. That was great.